And we are recording. Chair Schmidt, take the lead.
Yes, we're here for the Complaint Committee hearing on April 20th, 2021. Cheryl, could you go ahead and read the introduction?
Okay, we are the Complaint Committee of the Sunshine Ordinance Task Force. I will now read remote access to information and participation. In accordance with Governor Newsom's Executive Order number N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force webpage regularly to be updated on the current situation as it affects the legislative process. Would you like to read meeting decorum, Chair Schmidt?
Could you do that, Cheryl?
Sure. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave.
Okay, let's go ahead with the first item.
Item number 1, call to order, roll call, and agenda changes. I will do roll call. Member Forsley. Member
Present.
Forsley.
Present.
Member Stein.
Here.
Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. I do want to note that we began the meeting at 5:33.
Great.
Okay, we do have an agenda change. After I published the agenda packet on Friday afternoon, I received an email from Anonymous having to do with complaint number, I believe it's the last item on the agenda. File number 20096, complaint filed by Anonymous against Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner. The petitioner emailed me and said that she had received her records and wished to withdraw her complaint.
Oh, withdrawn. Okay.
Not withdrawn. That's number 10.
Yes, item number 10.
For some reason, I thought that one was postponed, not withdrawn, but that's good.
She asked if she could postpone it, and then I heard from her later saying, "Oh, I wish to withdraw this."
Okay.
So that's what happened.
Okay, good. And that's one of several anonymouses, even though they all use the same name.
Yes. Okay.
And do we need to talk about waiving rules today?
Well, I don't think so, because the two anonymous complaints are the same person, and it's just two of them, which is the limit that we typically have for task force hearings. So I think we should be okay. We don't need to have a discussion or a motion.
Yeah, it doesn't look like it, but I see that it's in the agenda. Let's go ahead and just not worry about that, and then move on to number 2, I guess.
Okay. Item number 2, approval of the March 23, 2021 Complaint Committee meeting minutes. Does anybody have any changes? I'm seeing Dr. Stein shake her head no.
No.
Kai, what do you think? Member Forsley?
No.
No? Okay.
Nothing from me.
Nothing from Dean Schmidt, or Chair Schmidt. All right. Then I will consider the minutes to be accepted, and I will upload them tomorrow for final draft.
Can I just ask one question about the minutes, though?
Yeah, absolutely.
Yeah, so this is Member Stein. I'm just wondering if we responded to, I think it was Mr. Hooper's comments in item 3, that he wanted to know when his file might be heard.
Mr. Hooper has 2 matters,
Okay.
and
19062 was the one he asked about.
6.2, the complaint committee, I believe, said that they were going to recommend that complaint be forwarded to the task force with a recommendation to close the matter.
Okay, but did we get back to him on when that might happen?
We don't know when that might happen.
Oh.
I haven't set that schedule yet.
All right, just checking.
Yeah, he also has another item, and he has to review his list and the documents that he has received, and from what I understand, that hasn't happened yet, or he hasn't done it completely.
Okay, all right, thank you.
And for efficiency purposes, his cases should sort of roll together still, even though our recommendations may have been different on them.
Exactly.
Yeah. I guess unless there's anyone else with questions, maybe we should put this up for public comment on the meeting minutes.
Anyone to make public comment for this particular item? The minutes of March 23rd?
Any public comment on the meeting minutes, item number 2? If not, we'll move on to number 3, which will be general public comment. But if there's nothing on this, sounds like nothing. Okay, let's go ahead, Cheryl. Let's go ahead and call for number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. And is there anyone here today who wants to give general public comment?
Yes, this is anonymous, please.
Okay. Are you ready, sir?
Yes, I am.
Go ahead, sir.
Thank you. First, I believe number 2 requires some sort of motion, so you may want to go back and make a motion to approve. But regarding general public comment, there seem to be a few people who did not know how to access this meeting, and I noticed that the agenda says public comment call-in, and you may want to change that to hearing parties and public comment call-in so that everyone knows that this is where everyone is supposed to come, not just people who want to make public comments. So I believe some of the respondents emailed everyone like a reply all asking how do they access this meeting. So you may want to change that. The second thing is about I guess it's not on the agenda anymore, so this is where I would speak about it, about the other anonymous who had a complaint today. That person's anonymity was not really well protected. Throughout that hearing file, you can see their name, their full name, email address, but you can also see their phone number. And so it's kind of hard to be anonymous if those things aren't being removed from the record. Thank you.
All right, thank you.
Victor, I have a question. Am I correct in saying that it is the petitioner's responsibility to redact all their records before they submit them?
Yes, we as the clerks of this committee do not redact personal information. It is up to the complainants to submit forms that eliminate all identifying information. We do not redact it as the clerks of the Sunshine Ordinance Task Force. that's one of the problems with anonymity. Unless they take precautions before they file a complaint, it's very difficult for us to maintain the anonymous status of applicants. It's up to them to take the steps needed.
Okay, so it sounds like we have a practice in place on that specific question. That's good to
Yes,
know.
it is on our application form itself that says we will not redact information provided to us in the application form or any of the submissions.
Okay. Thank you, Victor, about that. Okay, so Cheryl, unless you had anything else to add with regard to the last item of public comment, we should check if anyone else wants to submit general public comment.
I would like to.
Okay, we have at least one, and I guess it sounds like if we have issues with parties who may not have a call-in, we'll have to deal with that when we get to that. But at least the instructions are clear with regard to public commenters. So I don't think we should worry about that quite yet. But let's go ahead with the next person. One person more, or was there more than one more? Okay, go ahead, Cheryl, whenever you're ready.
Okay, is this anonymous number 2?
Well, this is actually Zach Carnazes. I'm one of the complainants on file today, but this is not related to those complaints.
Okay, you ready, sir?
Yes, I'm ready. So my general public comment is that the way these meetings are being, oh, do I start now?
Yes, go ahead.
Okay. My general public comment is the way these meetings are being conducted are completely different from every other meeting I've attended during the pandemic, which has been many. I mean, like dozens of government meetings. Normally, there's an automated system that says press *3 to be heard. And normally we have some access to video. It's kind of surprising as a complainant that I cannot even access this meeting via video. And I'm wondering if that could be possibly changed. That would be really nice to have a more inclusive meeting that actually looks and feels more like an in-person meeting with the video option and a little more clarity on how to navigate this very unique meeting right now. Additionally, I had a question about when someone with a city department is handling a case and they leave the city department, it seems to be, I've been told by the Department of Technology, it is the practice to delete all of their public emails within 14 days or 30 days or something like that. And I'm wondering if anyone can answer like why that is and if that can change, because I had another case where someone was actually investigating a case for me and it was my case, and that person, left their job and I didn't know that they left their job, and all my records that they were holding on to got deleted, all the records in their email. And so that seems like a pretty egregious issue to have in the city, where Department of Technology is just deleting records of employees after 14 days when they leave work, when they leave the job, without notifying the cases that they're handling for people. And so that was the second public comment topic. Thank you for your time.
All right, thank you. Anything from any of the members or Cheryl, Victor, before we move on?
Can I just follow up with Mr. Carnazes?
Please do.
Yeah, I'm just wondering, like, who told him? Does he have any documentation that they said that they're deleting emails within 14 days?
And this is Member Stein.
Yeah, sorry, this is Member Stein.
Should I respond?
Do you have documentation that you can provide us on that, so that if we follow up, we can show what we definitely was communicated to us? Yeah, you can reply.
Yeah, you may respond.
Okay, sorry, this is a very informal meeting. I'm used to like automated voices telling me to do certain things. I will be more than happy to provide that. I'm actually, as far as I understand it, I do have a right to open a case around this issue. So I think that's what I'll do over email, and I will provide the evidence then for all of this.
Okay.
All right.
Thank you.
Sure.
Yeah. Thank you for your comment. And we'll hear from you very soon again, since you are numbers 4 and 5. I guess let's move on to number 4 now. Cheryl, could you call the case?
Yes. Item number 4, file number 20065, complaint filed by Zach Carnazes against the Department of Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and complete manner.
Okay, members, as we go through the cases today, I would like to just ask that any of the members feel free to ask questions, to delve into anything that you find is appropriate for the task that we have at hand here, because this is a complaint committee meeting, so we're not deciding the case. We are looking at some preliminary issues, and then we may or may not have certain recommendations, reports to give when this goes to the full task force. But I'd like to just dig right into any questions we have for the parties, and the parties will get their opportunities to present their full cases. And if we need more information from them now, we can get it. But let's go ahead and start with questions for either party. Let me find out, is the respondent present on line number 4 from the DPW?
Yes, I am here.
Okay, is that Mr. Steinberg?
Correct.
Excellent, thank you. Okay, let's, members, go ahead. Do you have anything that you want to talk to these witnesses about?
I had a couple questions that are here in my notes. This is Member Stein. One is really basic, and I kind of feel dumb asking it, and maybe it's even just for you. But are the mayor's emergency proclamations rescinded now regarding the Sunshine Ordinance? I couldn't find any information on this online when I looked. That's why I asked.
Yeah, I don't know the definitive answer on that. It's a great question because it affects everything we're doing here. As far as I know, everything that the governor did, everything the mayor did is still in place with regard to, Sunshine, Brown Act, CPRA. I may be wrong about that. It does feel like it's been a long, long time that we've been, in that status. But that's my knowledge. I don't know if does anyone at this hearing, and I open it up to the public. It's a great question. Does anyone have any different information on that?
Can I just say very quickly that as I understand it, the CPRA is still, it was never not in effect. It was just the Sunshine Ordinance aspects of it because of the mayor's proclamation. I hadn't heard anything about the CPRA changing during the emergency.
Okay, thank you for that clarification. That's much better stated. Okay, does anyone else have any further knowledge on that?
This is David Steinberg. My understanding is that those rules are still in effect. As the member stated, what was certain portions of the Sunshine Ordinance were suspended, which left the CPRA as the essentially the governing law over most aspects of our Sunshine request.
Thank you. There may have been someone else. Thank you, Mr. Steinberg. Someone else had a comment on that.
Yes, hi, this is Zach Karnazes. I would really like to say something about this case, but I don't want to speak out of turn. As far as the issue, though, about the mayor's order, I just wanted to clarify for people on the line who might not know what's being discussed.
Please
or
do.
Someone else wants to do that. There was an order from the mayor when the pandemic happened. A lot of departments were being reserved for emergency services, and so they had less staff available to handle public records. And so the mayor issued an order in March 2020, I believe. I don't have the exact date in front of me, but it basically said that the Sunshine Ordinance was not in effect in the same way that it usually is. And there's some differences to the Sunshine Ordinance during the pandemic. That's what I understand it. Anyone correct me if I'm wrong.
Thank you. Yeah, I think that's in accord with what our understanding is. Yeah, I wouldn't be surprised if, under most situations where things are kind of coming back, you would think that there would be new orders, but we'll see. We'll see. Any questions for the witnesses?
I do have some questions. This is Member Stein, but I am wondering if we want to give the witnesses a chance to speak first briefly on their perspective, because that might also help me focus or might
That's
answer
fine.
questions.
Yeah. Ms. Stein, I'm sorry, Member Stein. Let's go ahead and give each of the parties on this case a 3-minute presentation. Tell us about your case as requested, and we'll start with the petitioner. Cheryl, are you ready to start the timer on that?
Yes, I am ready. Mr. Karnazes, are you prepared?
Yes, hi.
Okay, go ahead, sir.
Thank you. Thank you for giving me the opportunity to speak. I want to emphasize that this case, number 20065, is vastly different from 20067. And there's two major differences, or one major difference and one thing that actually affects both cases. The thing that affects both, of course, is the pandemic and the mayor's change that we just spoke of. The second thing that actually made a significant difference is that the director of Department of Public Works, 10 days before my complaint was filed, 10 days before, the director, Mohammed Nuru, was arrested by the FBI on charges of corruption. And after further review of the evidence and talking with Mr. Steinberg about, this was a while back, he had mentioned that they were absolutely slammed with public records requests after Mohammed Nuru's arrest, which makes sense, right? Because media and all sorts of folks are trying to find out what happened there. And in the following months, Mr. Steinberg really, I feel like actually really did go out of his way to provide records on a rolling basis during a very difficult time for his department and for the city and the public on a whole. And not only did he eventually provide those records, and they were I can never say this word, voluminous. There was a lot of them, and they were very thorough, and I thought he did a good job. And additionally, he did what I requested and actually made the records available to the public, which was also very important to me. And so I wanted to take this opportunity to thank Mr. Steinberg for his efforts and to actually withdraw my petition.
That shortens the discussion. Yeah.
That you asked the right question, Member Stein. I appreciate that. So, Cheryl, obviously this case is going to go away. Do you need anything before we move on to the next case? It sounds like the petition is being withdrawn.
No, I don't. I will put Mr. Karnazes. Hang on, I'm going to stop my clock. I will put Zach's comments in the minutes, and they will be reflected as accurately as possible. And
Okay.
I will close the file when I get back to City Hall. I'll be there on Thursday.
Okay, great. And I want to thank both parties on that case, Mr. Carnazes, for understanding the efforts of the DPW, and Mr. Steinberg, also for your efforts in, I mean, it looks like there were huge amounts of documents in this situation. So I appreciate that. Okay, and so let's just move on. It is a different case, but with the same petitioner. Cheryl, could you call the next line?
Item number 5, file number 20067, complaint filed by Zach Carnazes against the Mayor's Office on Disability for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and complete manner.
Okay, members, one thing I want to mention on this one is I don't know if we're going to have any confusion about what it's about, but my understanding in reading through the file twice was, even though there's a lot of material in the file on this, initially at least, this was about meetings and information about meetings. But we may end up fleshing that out a little bit. And, you know, Mr. Carnazes, we maybe you have a different understanding. But I want to make sure that the scope is something that we talk about. Members, let's go ahead on this case. And let's give each of the parties 3 minutes to present their case. In the Mayor's Office on Disabilities, is there a representative here from that office?
Yes, this is Deborah Kaplan.
Okay, great. Okay, so whenever you're ready, Cheryl, let's give 3 minutes to the petitioner first.
Okay. Zach, are you ready?
Yes.
Okay. Go ahead, sir.
Hi, this is Zach Carnazes. Thanks for hearing this petition. This case is very, very different from the one that preceded it. I first made this public records request in January 31st, 2020. And my concern for the case is not the scope, it's being ignored for months and months and months and months trying to get access to public records. I made a request on January 31st for these records. I made it again on February 3rd. I again wrote another email on March 6th begging for a reply and CC'd the director of MOD. I'd already CC'd a bunch of folks, including Department of Technology, who, by the way, responded to me within 5 days, while the Mayor's Office on Disability continued to not respond. Then again, on April 15th, I asked for a response again. On June 11th, I asked for a response again. And then there's another request in May. It went on and on and on, months and months of months, just saying, can I please have access to records regarding my disability cases? I'm a disabled resident, District 9 resident, and I was just trying to access records and emails that pertain to records of my cases that I filed with the city. So my complaint is largely based on the fact that this department did not even bother to respond to me for months, which is clearly against the Sunshine Ordinance. And, you know, they've been claiming that, oh, you know, pandemic, but my request was filed over a month before the pandemic. It was filed in January 2020. And so it doesn't explain why I didn't get that 10-day or 14-day response, let alone even the slightest effort to provide any records until sometime in June. Ms. Kaplan provided some records in June, not the full records, but some records finally in June, nearly 5 months after my initial request. And I don't understand how that can be legal. Additionally, I did not get full accessible copies of the records until January 2021. Now, Ms. Kaplan might point out that they gave me some inaccessible records, or records that required some login to some special system in November, which again
30
is
seconds,
still,
sir.
Thank you. Which again is still far too late and not in compliance with the Sunshine Ordinance and the just reasonable time length to access public records. I should not have to wait a full year and have to write dozens of emails with my disabilities, which require accessible technologies to write, are extremely difficult and extremely taxing on my health and my time with a department that's supposed to be protecting disabled rights. Thank you for your time.
Thank you.
Thank you.
Excuse me, but at this time, I'd like to ask if you're not participating in this hearing, please mute your microphone.
We're still hearing the ball game.
Yeah. Thank you.
Okay, so we can go ahead. Let's hear from the respondent on this.
Hi, this is Deborah Kaplan. I'm Deputy Director for Programmatic Access at the Mayor's Office on Disability. The Mayor's Office on Disability has provided all responsive records pertaining to Mr. Carnese's record request from January 31st, 2020. The final and complete response containing over 400 files was sent, as he stated, on January 8th, 2021. Prior to that, he was sent records on a rolling basis on June 19th, 2020, July 22nd, 2020, November 10th, 2020, December 11th, 2020, and December 18th, 2020. The emails that were sent to him contain all the responsive records that we found. Some records that were requested were not provided because they were not responsive. There were redactions to all of the records, and there's also a specific timeline. In April, we informed Mr. Carnese that MOD was not fully staffed and was not able to gather the full materials as outlined in his record request, in large part because of staff reductions, and then staff were additionally deployed to be disaster service workers during the city emergency, and that delayed our response to get him the records that he had requested. And the records were then made available as staff became available to review, locate the appropriate records, redact them, and then make them available. And there were attempts to connect with Mr. Carnese to find out whether he had received records in several of the attempts that were made to provide him with records. We did not receive any replies, and so we decided to send him all of the records in January of 2021 to make sure that he had received them all. Thank you.
Okay, thank you. Any other witnesses on this matter who wish to speak? All right. Okay, so at this time, members, we can have any kind of discussion with, of course, the idea in mind that we have a specific mission here today. I'm not sure if there's too many difficult issues in this case, but go ahead. Anyone have anything to say?
This is Member Stein. I just have a couple questions for the petitioner. One is, did you eventually receive all the records that you were looking for?
I believe so. In a year later, yes.
Okay, and this kind of speaks to something that came up earlier in the meeting, but is there now no question about the recordings of the town hall meetings, that aspect of the petition? Because you didn't talk about it in your opening statement. So are we just looking at the public records request?
Thank you for mentioning that. So it was my understanding that that would have to be filed as a separate petition and that it would not be included in this case from my conversation with Cheryl with the department.
Okay.
If that's not the case, I'm more than happy to answer questions about that, but I was intending to file a separate case for that since it wasn't in, there was some confusion there.
All right, that's all my questions then.
Mr. Carnazes, is it still your intent to handle that matter in a separate case?
I was told that I had to, so I'm a little like confused. I would have prepared more like evidence around that. I have a lot of evidence around that, so I think it makes sense at this point.
Yeah. Okay. So we'll leave that alone. Yeah. We won't deal with that today. Sounds good. I did notice just among the members that the way that the requests were written was a little bit potentially difficult, because I think one of the requests was that Mr. Carnazes said he wanted information about any meeting that he had attended. And I wonder if that's technically a valid request, because maybe you're asking someone to determine, what meetings those would be. And if he intended, maybe there's a record, maybe there's not. That's a lot of possible research into maybe information that's not even available. So I'm not quite sure. I mean, I don't have any problem with seeing that this should go to the full task force. But that just sort of stuck out to me as a somewhat odd request to have to respond to.
I might be able to help clarify that if I may.
Yeah. If you have a clarification, please do.
Sure. So I worded that part of that one part of it was not worded the best, and I was basically trying to get help with records of times I had addressed the council. MOD explained to me much later that like you just said, that is actually a really hard thing to know about or to dig up, and that they couldn't provide that. And in which case I totally understand that. And so that is not part of my complaint here at all. I'm not at all faulting MOD for not providing something like that, which I think they explained was a hard thing to provide.
Okay, thank you.
So this is Member Forsley. So it sounds like the issue has technically potentially been resolved, but we're kind of looking at the timeline and time frame and holding them accountable for the time frame situation. So if that's the case, they can be violated on something to do with the time frame, but also noted that he now has the documents. Mm-hmm. So that would be potentially how, that's how I would explain it if it came up at the full board situation, because it sounds like things have been satisfied on the actual documentation note of things.
I agree with that. This is Member Stein. The thing that seems really difficult here is that we have these emergency proclamations that change the scope of how sunshine is being understood during an emergency, and we don't even know if these proclamations have been officially rescinded. And I feel like just to deal with this issue and figure out, where we stand vis-a-vis the mayor and what expectations people should have of sunshine over the period of this COVID emergency, that we should move this forward probably to address that question.
Yeah, this is Member Forsley again. I agree with that. I think we should, and maybe in the interim, we can actually get clarification on the situation.
Yeah, I'm guessing that there wasn't that much effect, what the mayor did. That's just on this case, I'm not sure if it had an effect on this case, other than the fact that there were slowdowns in various parts of the city, just like everywhere. And so there were delays. But in terms of the legal changes to what's supposed to be done, timelines, etc., I'm not sure if this case was affected. And certainly it looks like this thing, it took him about a year to get the records to him. And I'm not sure if we can ascribe that to those orders.
No, but I'm just saying that, when I looked at the mayor's 5th proclamation, there were many, many proclamations, and I know the 5th one dealt squarely with the Sunshine Ordinance. I'm not sure if subsequent ones did or not, but it basically suspends the need to respond to requests within 10 days. It does sort of suspend all of those time limits, but then the question is, well, then is it reasonable for it to take a year? Because the 10-day limit has been suspended.
Yeah. And we certainly could try to figure out, is there some way to figure out the length of time that they're still allowed if that 10-day limit is gone. Is it forever? Is it a reasonable period? Who knows? I don't know. We could ask our council if they have an opinion on that. I
would
don't
also
know.
love to ask the council what the official status of these orders are now, because I definitely couldn't find anything that rescinded them online. And then there's this thing about, the mayor could go to the Board of Supervisors or the Board of Supervisors could affirm that these orders are rescinded. Like, I just don't know whether any of that has happened or not.
Yeah. Maybe if we send this case to the full board, we could make it a proviso that we find that information out first before the hearing. We could somehow get a request sent over. It could be, as I understand it, any of the members can make a request to our counsel at the city attorney's office to look into things. I'm not quite sure how fast that would be, that we'd get a response. But that's an option, and that might be the option to look at right now. Yeah, I mean, I see the delay here, and it sounds like that the question about the town hall meeting is not really part of this, and so it looks pretty straightforward at this point. I guess I'm ready if someone wants to make a motion.
Okay, I mean, I would make a motion that we forward this to the task force, noting that they did receive all of the information they requested, but that it took over a year to do so, and that the status of the emergency orders that suspended the need to respond to records of course requests within 10 days is unclear at the moment. I don't know if that's too much, but
Can I make a very slight clarification?
Sure.
Sorry, just for accuracy's sake, I filed on January 31st, 2020, and got the full records January 8th, 2021. So it was just under a year.
Okay.
Okay. Can we just also tack on that we did our job and found that we have jurisdiction and we have public records? Other than that, do we have a second on the motion?
I'll second it. Member Forsley.
Okay, so at this point, we can open that up to see if we have any public comment on the matter. Cheryl, let's go ahead and see when you're ready. Cheryl, are you there?
Yeah, I'm here. I just don't understand where the background noise is coming from because it's not.
Okay, we have some background noise.
If you are listening to this proceeding and you have background noise, we ask that you mute your phone, press *6, and then unmute your phone when you are ready to make a comment. And right now we have public comment for a motion to forward to the task force for jurisdiction and that the records are public.
Yes, is anonymous, please. Hello?
Yeah, I'm here.
Cheryl, are you ready? Hold on.
Hang on a second.
Yeah. Good.
Anonymous,
yeah,
are you ready,
okay.
Anonymous?
I am.
Go ahead, sir.
Thank you. This complainant filed their request significantly before, I believe it's March 24th is the effective date of the 5th supplemental proclamation that suspended the specific timeline to produce documents within 10 days. But as the respondent violated the law on, say, February 10th, the 10th day after January 31st, long before the mayor claims to have suspended those provisions of the law. Further, the CPRA requirements were never suspended, no matter when this person filed their request. That's, I believe, both the mayor acknowledges it and the city attorney's memo to the whole city regarding how the Sunshine Ordinance was impacted has that understanding as well, which means that within 24 days, they had to give a notice of determination to the requester regarding whether or not they had disclosable responsive public records to his request and an explanation for that determination. So I think the timeliness absolutely does apply because the mayor suspended the law quite after the timeliness had already expired for this person's request. And I believe the city attorney's memo also reflects the fact that implied in the CPRA is a requirement that no delay be unreasonable. And regardless of the mayor's suspension, even if the mayor's suspension did apply to the time this person filed the request, this should still be an unreasonable delay. Thank you.
Okay, thank you. Anyone else for public comment on this matter? Sounds like we're finished with that session of public comment. So let's go ahead, unless there's anything else, members, let's go ahead with the vote on this.
Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. The motion to send to the full task force for jurisdiction of public records. And also to include that the petitioner received all information requested, but it took over a year for him to receive his records despite the emergency orders.
Or Cheryl, this is Member Stein. You can say it took just under a year. The petitioner corrected that.
Okay. All right. Are we ready for the next item?
Yes, let's go ahead.
Item number 6, file number 19143, complaint filed by Anonymous against Sheriff Paul Miyamoto, James Wilson, and the Sheriff's Department for allegedly violating Administrative Code Section 6724, 25, and 27 by failing to respond to an immediate disclosure request in a timely and or complete manner.
Okay, members, what would you prefer that we do here? We could certainly ask each party to give a presentation, or we could just go straight to questions. Member Stein, it sounds like you want to hear from them first.
Yeah,
That's fine. That's
they might have urgent things to tell us, so yeah.
Got it. Okay, so let's go ahead. 3 minutes from each party. Cheryl, when you're ready, let's hear from the petitioner, and let me just find out is someone here from the Sheriff's Department.
Yes, Allison Lambert.
Okay, great. Thank you. All right, first petitioner and then respondent.
Thank you. Let me know.
Are you ready?
Yes, I'm ready.
Okay, go ahead.
This is Allison Lambert on behalf of the Sheriff's Office.
Hi. Which one? Do you want Anonymous or Miss Lambert?
Hang on, let's start this again.
It'll be anonymous first.
The petitioner will go first. Okay, you ready, sir?
Yes, I am.
Okay. Go ahead, sir.
Thank you very much. So this case is a request made at the end of 2019 on December 7th, which was a Saturday, as an immediate disclosure request for 10 government emails, 1 week of future calendars, 1 week of past calendars, and 10 emails from personal accounts, if any existed under the City of San Jose case of the sheriff at that time. Since it was a weekend request, it was deemed received on that Monday, which would be December 9th. So some sort of response was required by December 10th. No response was given until December 18th. So that would be an IDR issue. But more importantly, they gave this laundry list of exemptions in response to my request, stating that they would not produce documents exempt under the deliberative process privilege, which is banned, or at least was banned, or it still is banned, both in 2019 and now. They cited the public interest balancing test, which was banned at the time they made this response. They cited the CPRA's draft exemption, which is not the same as the Sunshine Ordinance's draft exemption, which severely limits the scope of the draft exemption. And then they cited a law that doesn't even exist. And I'm not sure what they were doing when writing this response to me. And I later found out that they've been doing this for everyone for a long time. They can't use these exemptions. And they can't also just throw all exemptions against the wall and see what sticks. They have to cite only specific exemptions that actually are relevant to what was requested. Issues happened after the complaint was filed. Whether you want me to discuss those or not, I'm not going to discuss them here. I'm happy to take questions, though, but that's the crux of the complaint. They can't just cite random exemptions, one, that don't apply, and two, that are not legal within the City of San Francisco. Thank you.
Thank you. Okay, let's hear from the respondent. Cheryl, tell us when you're ready.
Ms. Lambert, are you ready?
Yes, thank you, Chair Schmidt and members Stein and Forsley. This is Allison Lambert, legal assistant on behalf of the Sheriff's Office. The Sheriff's Office has learned from its errors in responding to Anonymous's public records request from December 7, 2019. We've taken remedial action in how we handle all public records requests, and we have implemented practices to improve our response times to all public records requests. These types of errors will not occur again, and the Sheriff's Office is attempting to be in compliance with both the Administrative Code and the CPRA for every public records request. Thank you.
Okay, thank you. Thank you. Any questions, members?
I have some questions. I was going to ask the respondent why they were relying on the deliberative process privilege and these other things that were, prohibited by the Sunshine Ordinance, but I don't think they need to respond to that, given the position that they're taking. But I did want to ask the petitioner whether they're satisfied with the sheriff's office response.
I'm not sure I'm not completely certain what you mean by satisfied. I don't think they should have cited any of these justifications.
Right.
But I did not raise in my complaint the issue, because at that time I didn't have them, the issues with the actual records received. So are you asking me about that or about the issues I've raised here?
Well, I know that you don't feel that they should have that they should have mentioned things like the balancing test or the deliberative process privilege. But now that they've said that they will not use those as blanket rationale for not providing things, are you satisfied with, I guess, their change in policy, not to use this form letter, not to, mention these exemptions that don't really exist, and their general position that they have learned from, they won't be repeating these errors?
No, but I would only be able to show you that in the next complaint. So.
Okay.
So just to keep the conversation going, this is Member Forsley. So it sounds like they are admitting that we can move this on to the full task force because sounds like the violations are being admitted.
It sounds that way. Yes.
Yeah. So.
Yeah. So I'm guessing that we will be moving this on. I have a couple of quick questions for the witnesses. Petitioner, is there still insufficiency in the response as to metadata?
That's correct. It's not just metadata, but there are other issues in response which I did not raise because I didn't know about them at the time I wrote the complaint. So.
Okay, so, but with the sheriff's office, is this matter going to involve metadata?
No, not as written. I think I believe what I've been told by the task force is I need to file separate complaints for that.
Okay. And the other thing is, well, let's see. I got two other things for you. There was an issue involving that the sheriff's office was releasing calendar items 3 days after an event. Are you contending that they're still, by doing that, as we stand here today, not in compliance with their obligations?
Yes, but that they're a bit confused. They gave a written response to you in this complaint when that issue about future calendars and how they produce them is in a completely separate complaint that's not even here today. So I think they just made a mistake and responded about that here. I didn't file a complaint about that here. So.
Okay, great. And I want to just ascertain, you were talking about the citing of random exemptions, citing of inapplicable exemptions. Did you have a reference for what rule that would violate if they cite an exemption that doesn't apply?
So I believe it violates both Admin Code 6727 and CPRA Government Code 6253C, because that is not actually a written justification for withholding information, and because it does not constitute an explanation for why the records are disclosable under the CPRA.
Okay. Thank you. No more questions from me.
I just have a quick one for Anonymous. Was that Government Code 625 (C)?
Sorry, it's Government Code 6253.
Oh, 3C, okay.
Unless we have any questions, members, any thoughts, any clarifications we should make amongst ourselves, or we could just work with a motion if you'd like.
Is there time for public comment?
Not quite yet.
Okay, sorry.
That would come after we have a seconded motion that's up to be considered and possibly voted on.
Yeah, this is Member Stein. I mean, it seems clear there's not a dispute that these are public records and that they're under our jurisdiction. So on the basis of that, I would move this forward. I'm glad that the Sheriff's Office now seems to have changed their form letter that they were sending out to people, but clearly it was, it seems to me that it was clearly violating the Sunshine Ordinance by citing things that as exemptions that aren't legitimate exemptions.
Member Stein, is that a motion?
Do we have a second?
Yeah, my motion is to move it forward. Yeah.
Okay. Do you have a second?
Yeah, I'll second it.
Okay. So now we have a seconded motion, and we can go on to public comment when Cheryl's ready to do the timing.
Do we have someone up for public comment?
Yes, hi.
Is that two people or is it one person?
I think I heard two, Cheryl.
Yeah,
let
him go first.
Okay. Are you anonymous, sir?
This is Zach Cornelius.
Okay. Are you the first public commenter, sir?
Yes.
Okay. Zach, are you ready?
Yeah.
Go ahead, sir.
So hi, first off, I just want to thank petitioner. He clearly put a lot of time and energy into this petition. We from the public are not paid a cent for the time it takes to bring departments into compliance with the law. So to hear someone from the Sheriff's Department saying, yeah, we violated the law for a long time, but we're doing better now, so all good, is like super concerning. I would think at the least they should go back and provide records to all the people they denied with this form letter. And I also want to take note that the representative from the Sheriff's Office said they corrected the error as if it was an accidental mistake. Nothing about what petitioner described appears accidental. To me, that sounds like a coordinated legal effort to brickwall the public from accessing vital public records. There are perhaps no records that are more vital and important to the public interest than for what our law enforcement, than records with law enforcement, especially during the COVID-19 pandemic. I would also like to note this is not the first time I've heard of the Sheriff's Department breaking the law. There was an order by the mayor, either the mayor or the governor, to close down 850 Bryant during the pandemic, and the sheriff left it open, breaking the law. And it was it took a large effort from people of the public to have it closed. And so I'm very concerned to hear this sort of legal brick walling of public efforts to access public knowledge. And clearly petitioner has some legal experience. And it's really sad to me. I wonder how many months or years have gone by that the public has not had access to records like this. simply because an anonymous lawyer didn't come forward to point out all the illegality going on here. So I want to thank petitioner. I'm very interested in learning more about this case. And yeah, thank you, petitioner, for your valiant efforts here in the public good.
Thank you. There was at least one more public commenter. Whenever Cheryl's ready.
Do we have another public commenter?
We actually, this is Lieutenant Parra. I'm with the San Francisco Police Department. I'm sorry to interrupt the public opinion, but we went out of order. I'm file number 19141. Are we still hearing that, or is that going to be heard later?
No, that case was not scheduled for today. That was going to be scheduled another day.
Okay, alrighty. So there's nothing for San Francisco then?
Not for the police department.
Okay, thank you very much.
All right.
Bye.
Any other public comment? In that case, let's go ahead with the vote.
Oh, can I say, this is Member Forsley. Can
yes,
I say
please. Yeah.
I just want to echo the person that just said what they said regarding this. It's a little concern. Well, little, I'm using like a hyperbole. It's very concerning that this situation happened and it had to be brought to the attention by someone of the public, just like doing due diligence. It seems a little wanton in this situation. And so when we move it to the full board, I feel like, or the full task force, I feel like there should be some more fanfare around this in terms of bringing attention to the fact that many people probably got this type of response before someone took it to, this level.
And I would, this is Chair Schmidt, I would recommend that when this case then does come up, you go ahead and speak, Member Forsley, about your impression in that regard. And I think that's a proper function of what we're trying to develop here in this committee hearing. It's part of our limited sort of scope of what we're doing. But if you have an impression like that, please push it forward to the full task force. Okay, I think unless any member has anything else at this time, let's go ahead with a vote on this matter.
Are we ready?
Yes.
Okay, we're ready for the vote. Okay, Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. The motion to find jurisdiction, the records are public, and to forward to the full task force has passed. We are moving on to item 7. You ready?
Yes.
Item number 7.
Let's go ahead. Yeah.
Item number 7, file number 20009, complaint filed by Anonymous against Sheriff Paul Miyamoto, Lieutenant J. Quantico, and the Sheriff's Department for allegedly violating Administrative Code Section 6726 and 27 by failing to justify withholding and keeping withholding to a minimum.
Okay. Members, would you like to have each of the parties make a presentation to start with?
Yeah, I would like to, and I would also say, I don't know, for me moving forward, if you don't feel the need to ask that question, I think it's helpful for me to just get like I don't know, just a baseline.
Okay.
So I'm fine.
Yeah,
with that forward.
That's fine. I want to keep the option open just for efficiency purposes, that, maybe we don't always do it, but it does seem like there's a consensus. We have a majority of people who want to go ahead and get a preliminary statement, and that's fine. That's fine with me. And I think we are moving fairly quickly here. and we're not stalling out on anything. And so I think we do have time to do that. So let's go ahead. First, from the petitioner, I think we allow 3 minutes for the petitioner and then the respondent. So Cheryl, whenever you're ready.
Anonymous, are you ready?
I am.
Okay, go ahead, sir.
Thank you very much. So this complaint is why I said in the last complaint I'm not satisfied with what the Sheriff's Department, how they've changed their procedures and policies. So in this, once I noticed what had happened in the last complaint, I made a request for all of their responses over approximately 1 year to every other person in the public to see if they were actually doing the same thing that they did to me to everyone else. They did, in fact, do the same thing they did to me to everyone else for at least 1 year. I didn't actually go back for more than 1 year. So both the public commenter and Member Forsley's impressions are evidenced by the 300 pages in this hearing packet. And what I'm complaining about is not what they did to those other people, but actually how they gave me the records of their responses to other people. This is after they had understood that what they were doing was wrong. They now didn't give any justifications for withholding information. And even though they had redacted information from these documents. And I'm sure, I assume now they'll tell you, well, we've learned that lesson too. But it's not my obligation to train or teach the city. It is Dennis Herrera, as a city attorney's legal obligation to train the city. I cannot understand why a law that has existed for, at the time I made this request, 21 years, would not be known by a department, a law enforcement department. And yeah, this record is actually the evidence that they've been doing this to other people for a long time. They then redacted information from the records that they gave to me. They did not justify that until after I filed the complaint. I would ask, if you can, to combine this file into the previous file, and we can just have a single hearing for all of them if you're able to do that. Thank you very much.
Okay, that would be taken up at the task force.
Yeah, I think Cheryl's got that figured out. Is we can do the combining, but not today. We'll do it at the task force. So thank you, and we can hear from the respondent now when Cheryl's ready.
Is the respondent available?
Yes.
Okay, and this is, who's this from again?
Allison Lambert on behalf of the Sheriff's Office. May I proceed?
Hang on a second. Go ahead, ma'am.
Thank you, Chair Schmidt and Member Stein and Forsley. The Sheriff's Office acknowledges errors were made regarding these redaction justifications. Upon notification of this error, we offered to provide a revised production to Anonymous, didn't receive a response, and received the complaint, upon which we were able to take the time and produce the production with justifications. We have implemented changes to our practices to make sure that this doesn't happen again, and we are watching each of our CPRA requests and sunshine requests to see whether justifications are required for any redactions that go out for any of our productions in the since then. Thank you.
Okay, thank you. This is on behalf of the parties here today. Okay. Members, any kind of questions you might have?
I don't have any questions per se. I guess it sounds like this was an exercise. This particular case might have been an exercise in showing that there's kind of like an egregious issue going on. I am sure that it could be a matter of training, but sometimes with these positions, people just get the positions because of who they are and stuff like that. So I personally don't necessarily know if they knew what they were doing or if they were trained properly or if even they had benchmarks of training to keep their positions, because some people just get to keep positions no matter how bad job they're doing. So I do think obviously this will be moved forward. And again, I think it needs to be, I think we had talked about at the full board somehow the information being siphoned, or the full task force being siphoned to more of a direct line to the Board of Supervisors, and something like this is very concerning.
Okay.
Okay, and this is Member Stein. Again, I don't know if the petitioner will like this question, but obviously you don't feel that their process was correct. For some reason, I got the impression when I was reading the file that you didn't agree with their citation of CPRA 6254C, their reason for their exemption, but you were just objecting to the fact that they didn't, in their initial response, give reasons for those exemptions, or are you objecting to their particular citation of CPRA 6254 about withholding personal information of previous petitioners because of unwarranted invasion of personal privacy?
Sure. So it's both the fact that they didn't give any written justification, but also I have a supervisor of records response that says the identity of requesters is public information. It does need to be disclosed. The address, home address, emails, telephone numbers, that can be redacted under 6254C, but the identity of a records requester should not be withheld.
So, and they're continuing, but in the second production, they did reveal the names, correct, of the requesters, just not their contact information.
So I'm looking at, well, they've responded, I believe, 3 times to this. They supplemented the response. So I don't know which page number you're looking at, but let me give you a page number here. The page number on 676, for example, has no information at all about the requester. And I'm not sure if that specific one has been resupplied. If they can represent that they have provided the identity of all requesters, then I would agree that there's no more disclosure that I would ask from you, except for on page, the first redaction on page 683.
I'm just trying to look.
So they claim that that is Corey information, but I believe that this is not information they got from Corey. It's information that I presume this is an incarcerated person, sent to them in their request. I don't believe it's the sheriff's Corey information derived from Corey.
Okay. Yeah, just because looking at this last question that they submitted, it looks like most of the names of the people who made requests are there. Just for most of them, the contact information is not there. But I'm glad to hear that you're okay with just the names being revealed and not necessarily people's personal contact information. And then I had a question for the respondent, which is, can you tell us a little bit more about who exactly is responsible in the sheriff's office for handling information requests and what their process is? Because it seems like some interesting policy decisions were made. You talk about there being a retraining, and I'm just wondering if you can give us a brief sense of who is responsible there now to respond to these requests, and what is their general process?
Sure. If I may, I know this is out of order. Anonymous was talking about page 683 and criminal record offender information being redacted. Yes, this we cannot release information on whether somebody is incarcerated or not. And so the information that was redacted here on page 683, it's criminal history. And so that's the reason for that redaction. Now, addressing your question about who handles this, the Central Records and Warrants Unit has a staff of 5 that is currently responding to public records requests. We've also purchased software, public records software, to help us with calendaring at deadlines, and the Director of Communications is also very involved with multiple public records requests as well. In terms of training, the 5 staff members attended public records request training through the CPOA, and myself have attended numerous online learnings on the Public Records Act.
But these are for CPRA, not for Sunshine Ordinance?
I can speak for myself for learning about the Sunshine Ordinance. When I came on board with the Sheriff's Office, the first month of my job was spent reviewing it and learning the Sunshine Ordinance.
Okay.
All right. If anyone, go ahead if any questions come to mind, but we also can discuss it if you like right now. This one does look straightforward. I think any motion we should include a recommendation that the 2 be combined, so we don't get bogged down in that at the task force level. It sounds like there are changes being made, but we're not, we should recognize changes as a good thing. We should recognize, certainly when someone is a change agent, we should recognize that effort. But we're also here to just determine, whether this should go before the task force and not decide the case. All right. So should we handle this by a motion?
This is Member Stein. I'll make a motion that we forward this to the full task force with a recommendation to combine, what we have as agenda item 6 and 7, those 2 cases that are handled in currently separate agenda items.
And I will second that. This is Member Forsley.
Great. Thank you. So, Cheryl, let's go ahead and move on to public comment on that. Cheryl there? Cheryl, are you there? I know Cheryl said she might have a problem somewhere along the way. If Cheryl's not, there you are. Sorry.
I did have a problem. I did go offline. So I had to get back on. But now I'm here. I heard the motion. We're ready for public comment.
Okay. Is anyone present who wishes to make public comment on this matter?
Motion.
It appears we may not have any public comment. Anyone who wishes to make public comment? So we can go ahead and move on to a vote on this matter.
Ready for a vote?
Yes.
Member Stein.
Aye.
Stein, aye. Member Forsley.
Aye.
Forsley, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. The motion to forward the matter to the full task force, recognize that there is jurisdiction and that the records are public, with a recommendation to combine items number 6 and 7, 6 being item number 19143 and 7 being 20009. That will be brought to the full task force.
Okay, thank you. Now, at this time, we've moved through 4 cases, and it's 6:58. And the seventh case is not happening because she's dismissing that matter. So we have two matters, both involving the same petitioner. We can take a break if people want to take a 5-minute break, or we can push through. I'm assuming this is probably the best time for a break if we're going to do that. Everyone want to take a 5-minute break?
I would appreciate a 5-minute break.
Okay, great.
Right.
Actually, I'll call it a 7-minute break. So let's come back at 7:05.
7:05.
Yeah.
Okay.
Anybody not here yet? It's 8:05 or 7:05, sorry. I think, see, Member
That's on
Stein.
line. Waiting for Member Stein.
Yeah, looks like it.
Sorry, I am here.
There we go. I thought maybe she was. Yeah. I guess we can go. So let's, if everyone's ready, let's move to the next case.
Item number 8, sir.
Yeah, go ahead.
Item number 8, file number 20093, complaint filed by Carl Kramer against the Department of Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner.
All right, we'll go ahead and hear 3 minutes from representatives of each. And I did ask earlier, and I'm going to assume that Mr. Steinberg's still here. If not, please indicate otherwise when it's your turn responding. But first, let's hear from the petitioner.
Hi, this is Carl Kramer with the campaign co-director for the San Francisco Living Wage Coalition. And this has been a kind of a...
Hey, hang on a second, sir.
What's that?
You need to wait to provide your statement, sir.
Oh, okay. I thought he said to go ahead.
No, that's okay. All right, I've called item 8. We are now going to hear from the petitioner, Mr. Kramer. Go ahead, sir.
Thank you. Yes, Carl Kramer, San Francisco Living Wage Coalition. And this has been kind of a long-standing campaign to educate department heads about amendments to the minimum compensation ordinance and the effect that they had when they were passed in late 2018 on what departments would need to submit with their budget proposals. And part of that is that there is a provision in there that when departments submit their budget proposals to the mayor's budget office, they include a written confirmation that they've taken into consideration in their calculations the effects of the cost of living adjustment that takes place every July 1st based on the Bay Area Consumer Price Index increase. The intention of that language, and we were there in the room when it was being drafted, so we know this, was that if the department doesn't, include that amount to cover the increase for city-funded nonprofit workers, that they then submit, their calculations on how much that increase would be. So then the mayor's office, budget office, or later the board of supervisors would have the figures that they would need to include in the budget. And the reason for that is if there isn't adequate funding put into the budget for those wage increases for the city-funded nonprofit organizations, the controller's office at the end of the after the budget's been passed can say, well, I can't certify that there's sufficient funding in the budget for that wage increase, and that wage increase is deferred. So, the departments are aware of this. We submitted an information request on June 1st for what are the calculations of the Department of Public Works and what, a copy of their written confirmation. The July 24th, they sent an email saying that they couldn't, that we weren't describing identifiable record or set of records. We filed a complaint on July 25th, and then they, after that, you see on page 778, they then responded, well, it's not their responsibility to do those calculations. That's the responsibility of the controller's
Your time is up, sir.
Okay.
Thank you. We will probably have a few questions for you after we hear from the respondent. And as soon as you're ready, Cheryl, let's give a turn to the representative for the respondent.
Mr. Steinberg?
All good? Ready to go? Thank you.
Go ahead.
Good evening, Chair Schmidt and members of the committee. My name is David Steinberg. I'm custodian of records for San Francisco Public Works. This complaint is similar to one that Chair Schmidt was heard earlier this month or last month, that heard before EOTC. And the basic, part of the problem is that, as Mr. Kramer said, they're working on a campaign to educate departments, and honestly, that's what his letter appeared to be. He wrote they submitted a 13 paragraph email to our deputy director of finance, who read it, didn't recognize it, it didn't sound at all like a records request. And so she forwarded it to our budget folks to get information. The first time that I was made aware that a potential request was made was when Ms. Leger notified me that a complaint had been submitted to the task force on July 23rd. So I checked with our director and his secretary to determine if a request had been received by email. Both confirmed that no request was received, and our department had actually said, when he read it, it says, it doesn't appear to be a request. To the contrary, it reads more like an affirmative statement. But that same day, I contacted Mr. Kramer, asked how he submitted the request, and then went about trying to find the information he was looking for. Again, we provided, we provided quite a bit of information to him, even though, again, it wasn't really clear to us what he was asking for. But I went back to our budget folks several times, and they produced several documents which appeared to be what he was looking for, and we sent that to him. Again, as was the case last month with the EOTC, the ordinance requires that a department affirm that they are taking these things into consideration, but there's nothing that says they have to provide any sort of written calculations. And in fact, that such a document doesn't exist. So all I can say is we provided all the information we could. I'm sorry that no one of the 5 people who saw the email recognized it as a records request, because it didn't sound like one. All we. Sorry. Thank you.
Thank you.
Thank
you, sir.
Okay.
Any other witnesses on this matter? Okay, members. Any questions? I did attend a hearing as a substitute, and there were 2 very similar cases. I believe Mr. Kramer has a series of these, almost identical, just with different departments. And so I have a little bit of background on his issues. Yeah. But if any questions are welcome, go ahead, Member Stein. You're muted.
Sorry about that. Okay, for Mr. Kramer, I just want to be clear. You did not get the documents you were requesting, or did you?
I did not.
Okay, and then for the department, for DPW, did you prepare any budget requests or funding allocation requests for 2020, 2021 fiscal year?
The department did, and as required, the department checked off an acknowledgement that the provisions of the MCO were considered as part of the budget submission. That's all that the ordinance requires, and we provided that to Mr. Kramer. That would be as close as we could get as a responsive record to his request. We don't have calculations, they don't exist, and the ordinance doesn't require departments to produce them.
So then it is your understanding that you do not need to submit a written confirmation that you considered it, or you just consider that checkoff to be your written confirmation?
We do have to provide written confirmation that we considered it, and that's the form that I provided a copy to him, as well as in 2 subsequent requests for other years. We did provide that documentation that we took those ordinance into consideration when submitting it. That's what the checkbox is in a sign.
Okay, so that form and the checked box is your confirmation that you considered it, but you have no line item in any proposed budget showing that consideration. Is that correct?
Correct. Those calculations. There are no figures on that, and that's exactly what the other 2 departments said last month. They don't exist. It's not part of the process. In fact, as it was explained to me today when I talked to our budget director, he said that the information wouldn't be available yet because so, for example, right now, we don't know what the MCO rate is going to be for 21-22 or 22-23 yet until we get figures from OLSE. But we acknowledge that we will, of course, include that in our budget. Those calculations, when provided, will be part of our budget. So it depends if you're talking about previous year, current year, or next year. But there are no documents with any such calculations, and as I said, the ordinance doesn't require it. We told them we don't have anything else.
So this is essentially a disagreement. I guess this is a question for Mr. Kramer. Is this a disagreement about what the ordinance requires?
The ordinance says considering calculations, so it's just checking off the box on the budget submission checklist is, and then it's signed by the finance director. That's saying that they have taken into consideration calculations that, and we want to see the underlying calculations. We do know the figure, and it's increased from 1705 to 1734. Currently, at that time it was the increase. This was last year, increased from 1650 to 1705, and that because it's based on last year's CPI increase, or the previous year's CPI increase. So that can be confirmed with the controller's office, and we shared those figures with the Department of Public Works, so they were aware of those figures. On page 800, their response on August 14th was that they had no documents responsive to our request. And then August 24th, they then come back and send a copy of the budget submission checklist. And then they give the calculations for the 2019 increase, which was not what we were requesting.
And are you saying, Mr. Kramer, that the calculations for the next fiscal year should have been available and appeared somewhere in their budget, or there should be some written documentation that they actually considered it?
The mayor's office is saying, well, you can just check off the, that checkbox on the budget submission checklist, and that should be your written confirmation. And, we're not going to fight over what the form and the written confirmation is, but, it's clear in the ordinance that it's consideration of the calculations of what the effect of the increase. And the first year of the increase after the 2018 amendments, the controller's office handled that first year just as a demonstration of how you are to arrive at making these calculations. And I have an email from Michael Minton at the controller's office to just confirming with him. The question was, is it the responsibility of the departments to estimate how much they would need allocated for the annual MCO cost of living adjustment? His answer was yes, departments are responsible for working with their contractors to learn whether any workers on city contracts require a raise per MCO and the cost of that increase. So that, not saying that they have to have those calculations, in their budget proposal, but it would make sense, at some point the mayor's budget office could turn around and say, well, what is your calculated increase? We want to consider whether to include that in the budget, whether the department put it in or not.
And forgive me for being...
I want to just interrupt for a second and ask that everybody mute if you're not speaking, please mute your microphone because we are getting background noise. I apologize, Dr. Stein. I just wanted to be quiet so you can all hear that.
Okay, and I'm just trying to make sure I understand the implications of this as well. Is it your concern that if you don't see evidence of that calculation or that it was included in a budget proposal that there may not be funds to have an appropriate cost of living wage increase for nonprofit workers?
That is our concern. I mean, we, this last budget cycle, we were kind of driving blind and trying to come up with, our calculations of what the Board of Supervisors needed to put into the budget as an add back. The idea of this language in the ordinance is that that the mayor's office and the Board of Supervisors hear from the departments, what their calculations are based on what their discussions have been with the nonprofits with which they contract. But without those figures, then how in very late in the budget season when the Budget and Finance Appropriations Committee is trying to put together the list of add backs, how do you calculate what amount would be considered by, at the end of the day to be sufficient funding?
Okay, and so my last question, sorry I have so many questions, is for the representative from DPW. Can you describe to me how you considered the provision in the MCO when you checked off that box? What was the nature of your considerations? And please be as detailed as you can be.
I can't speak to that because I'm not in our finance department. But the request, if you read through his request or his statement that came in, one paragraph says, and this is the only part that would be considered a request, we're requesting the written confirmation that the department took these costs into consideration and the amount that the department allocated to nonprofits for these costs. We provided him the written confirmation that the department took these costs into consideration. I went back to our budget and finance people multiple times. Again, it was, as Chair Harlan of EITC mentioned at last month's hearing, they really weren't clear on what they were asking for. And so I went back multiple times and I asked our budget and finance people, you know, are there any other things that would potentially be considered responsive to this, or anything else we can give him? And I sent him, you know, I contacted him multiple times and I sent him multiple things. But the thing that he literally asked for was confirmation that we took the cost into consideration. And I provided him the document that was checked off that said the department considered them, it took them into consideration. It's like he's said several times, and in other cases as well, that you know, it's implied under the ordinance. It says you have to do this, and so therefore it's implied that there must be some calculations, written calculations that can be provided. But that's not what the ordinance requires, and we don't. As explained to me, our department doesn't do that. So we have nothing that we can provide him. So we've given him everything we can. And you know, we're not required to create documents that don't exist, but that's all we can do.
Okay. Yeah, so the thing that I'm just trying to wrap my head around is it seems like it's a dispute over a process that has been encoded in an ordinance approved by the Board of Supervisors, you know, that requires a certain document be produced, right, saying that something has been considered. And DPW is saying they did that and they have no other evidence of consideration, any budget line or any other documentation. And I do think the Sunshine Ordinance can only give access to documents that actually exist. So I'm just wondering, like, is this really, should this be a matter for the Board of Supervisors, that maybe this policy isn't clear enough? Or is this something that we can forward?
And I think that's sort of, I think Member Stein, you were sort of posing that to those of us who are the members.
Yes, I'm sorry.
correct me if I'm wrong.
No, you're correct.
I'm pretty much with you on that. I'm just gonna, if you don't mind, I'm gonna just ask a couple of quick questions to sort of show what I'm thinking about in that vein. Mr. Kramer, a quick question to you. After having seen what you've seen from the DPW in this matter, if you look back at the way you made the request for them for a document, is it your understanding that the document you requested
Chair Schmidt, if you don't mind me interrupting a second, I'm going to mute everybody. And the background noise is getting really bad.
Okay. All right. I think we're good. Thank you, Victor. Basically, my question is, does it appear to you that the document you requested actually is not a document that ever existed and does not exist at this time? Question for Mr. Kramer, that is.
He probably, yeah.
I did mute everybody, so you can press star 6.
I'm sorry.
I was hearing the recording that I was being muted while you were asking your question, so I heard nothing at that point.
Sorry, I'm sorry. There's a lot of technological wizardry going on, and I love it. I just love it. Okay, I'll ask my question again, Mr. Kramer. Is it possible, based on what you've learned about the process at DPW and what you have received, that the specific document you asked for actually doesn't exist and never existed?
Well, it's a little hard to accept because it is.
Well, you don't accept it, but it is possible, right?
Well, when on one date we're being told there's no documents responsive to our request, and then on another date, then we received the written budget submission checklist. Okay, that's a document, but
That's
still,
not the document you asked for, right?
well, we were expecting a document that would show calculations at that time.
And that's what you asked for, right?
And that's what we were requesting, yes.
And they've never given that to you, right?
They sent one that was from the previous year, that was from the controller's office.
Okay.
What we were requesting was the calculations for that current, that upcoming budget year.
Yeah. Now, the reason I'm asking you these questions is we've got a very limited scope here at Sunshine, and we don't enforce other laws. We can't tell people how to, do their jobs other than in these document production and public meetings issues. And it looks to me like what your request has revealed is that possibly they're not in compliance with what they're supposed to be doing over there at DPW. And I believe that might be your contention. However, it looks like Mr. Steinberg says they've given you documents that may be responsive, but the document that you specifically are requesting, he says it just doesn't exist. And so that's what I'm wondering about isn't that a possibility?
I would say I suppose so.
And you feel that would be a violation of the ordinance if that document didn't exist?
I would say that the not having the calculations in whatever form that they are, because the budget submission checklist has been checked off that those calculations been considered, and that was signed as a statement. And so that it would lead us to believe that somewhere there are calculations.
Okay. That pretty much is what I'm thinking on the lines of what Member Stein is thinking here too.
Yeah, and I'll just repeat it if I can, just because my sense is that there are no calculations. They say they've considered it, but they have no evidence that they've considered it. And then it really becomes a question of how did they consider it? And it may very well be that there is no other record, and that the contention is, what needs to be done in order to have considered it? Does it need to be a line item in a budget? Does there need to be calculations that got folded into a budget? But if those aren't there, they're just not there. So there's no record that we can ask them to produce if they don't have a record of it. But it would be the fact that they don't have a record of it may in fact be evidence that their consideration was quite limited.
Yeah, and I think that this is a case where I think that the Living Wage Coalition has found out what they're going to find out in submitting the request, and whether they're satisfied with that is not really what we can do anything about. And so, with some of the other requests that they've made to other agencies, maybe they haven't gotten to the point where they really, have found out anything. And so those kind of cases, I think, should move forward. But I don't know. I don't know if we should recommend that this thing go to the full task force, because it sounds like we know that the document that was specifically requested, it just doesn't exist. And I think Mr. Steinberg has said that. Whether or not that's non-compliance with the ordinance, I don't know. Now, we can't, I guess we could, well, I don't know if we say the documents are public, the documents that may or may not exist would be public. I don't think there's any question of jurisdiction, which are sort of our tasks A and B. We could make a recommendation or make no recommendation. But we either send it up or, I'm not sure if there's an option of not sending it unless we find that we can't find either of those.
Yeah, I mean, I think it's clear that it was more than 10 days between requesting at least, there were two items in the request, right? There was this written confirmation that this thing was considered, and then there was evidence of the consideration, like some kind of documentation documenting, how it was considered. And even that piece that asked for a confirmation that there was a notice sent that it was considered, that seems to have taken longer than 10 days and longer than the time limits set out in the Sunshine Ordinance. But I guess my question is to Mr. Kramer too, is whether you would want to move forward with this when it seems clear that there was no concrete evidence of how that ordinance was, how the cost of living increases were considered.
That's a question to Mr. Kramer.
Yeah, that's a question to Mr. Kramer.
So you're asking whether to move forward just on the timeliness of it?
Whether you think this is, yeah, I mean, we could move forward on the timeliness, right? Because it didn't fall into the time frame of the Sunshine Ordinance. But I just wonder, as a kind of advocacy group, whether this is the route that you want to go forward with, or just to save you might want to consider other things too, like talking to the Board of Supervisors or the representative for your district about how this process is being understood by different agencies, and maybe not complied with in the way that you believe it should be.
I had sent an email to Mr. Steinberg that if the department would provide calculations for this upcoming fiscal year, because we know what the increase will be. It'll be from 1705 to 1734. That we would withdraw this complaint. We're interested in seeing departments, following this process. If the language is already there. If we have to go back to the board to then get further language, I mean, at what point do we get departments to follow, what's already there in the ordinance?
Right. So can we ask Mr. Steinberg, like, is this something that you believe your finance people can provide in the future? Some kind of demonstration or evidence of how this was calculated in their budget proposals?
Well, in fact, I will say one thing. As I said, the initial letter that came, no one saw it as being a records request. It seemed like a educational material. But subsequent to that, his group has submitted 2 other requests, which were more specific in what they were asking for. They were asking for, in one case, specific they wanted the calculation, or they wanted the confirmation that we did it, as well as a few other things, and we provided those to him. And what he was just referring to, they submitted a new request on April 5th, and we responded to it by the 15th, and we did. There weren't calculations as such, but what they asked for was, we're requesting information on your department's allocation of these funds to nonprofit organizations with which you contract. And we did release that to them, and it's a spreadsheet that shows the grant programs as of April 14th, the total expenditures, the sum of the expenditures, 3% CODB. It lists all that stuff. So as far as I tell, we did respond to his most recent request. I'm not really sure how else, what else he's looking for.
Yeah, just to respond very quickly to that, I can understand maybe there was how the two different requests got confused. So the information that was sent was for another funding to nonprofits called the cost of doing business increase, and that was for this current fiscal year, 2021. The other request,
right, that's what was requested.
Yeah, the other request is for the calculations that would project what the effects of the cost increase would be for the cost of living adjustment that takes place July 1st, for this next fiscal year, 21-22, and we know what the increase will be. And and for the DPW, it's probably be the simplest for their department to do those calculations, because in their contracts it lays out all the wage rates of the people doing the work.
I'd like to. Sorry, let me just say quickly. I would like to affirm that I also noticed that the initial request letter, it could conceivably, be passed around, and people may not absorb every word on a reading, and so you could say that the request was buried in the letter, and that doesn't necessarily mean anything one way or another, but I think it's valid to say, couldn't you make it a little more obvious that you're requesting documents when you send us a letter? But that's not going to sway me one way or another. I just want to acknowledge it.
Yeah, I understand your point. We did put information request in the subject line.
Mm-hmm.
Yeah, which is good. And eventually it was cleared up, and sometimes that's how the process works.
Yeah, I mean, it's clear that I just say that the way the law is written, there's no specific form or way that you have to make the request. But just for the sake of clarity in the future, you might want to put the request right at the top, and then follow it with the explanation and advocacy, just so that it can't be missed. But it's fine to do it however you do it.
And I have no problem with the document you request. It looks like the ordinance is talking about a document that should be generated, my reading of it, but I'm not an expert in that area of law. I don't know, what they do, what they don't do. But you're very clear about what you ask for when you get to it. Yeah. It does sound like Mr. Kramer may want to go forward here with this. And if you can get DPW to, cut a deal with you so that you dismiss this, that's between you, between the parties. I don't know how much you're going to get more from us, other than maybe an order saying that there was a delay here. And that's what the task force could give you. But, we can't order that they generate a document that they can't generate otherwise. So that's where our limitations sit. But that's up to you. I think what we might want to just do is, pass this forward. If anyone wants to make a motion, any kind of recommendation, go ahead, tell me.
I can make a motion to forward this to the whole committee. I don't know if we can put in the motion that we don't believe that, that there were 2 documents requested. We don't believe one of them exists, but we think there has been, potentially a violation of how long it took to respond with the one document that does exist.
And at least some of them are public documents and we have jurisdiction. Can we add that?
Mm-hmm.
Just so that I'm clear, Member Stein is making a motion to forward to the task force. There is jurisdiction and the records are public, and to find a violation for time limits.
Right, but I just, it doesn't seem like any document was withheld. It just seemed that the document that was provided wasn't provided in the time frame of the ordinance.
Because they weren't sure what it was they were reading.
Well, it doesn't matter why, it just...
Yeah, okay, so that's, I just want to make sure I get the motion right. To find a violation of timeliness. Is there anything else?
Timeliness, but just to clarify, not a withholding. Yeah,
Mm-hmm.
I think that's that'll help us later.
Yeah, just to streamline it when we get to the full board.
Excellent. Yeah. Member Forsley, any comments on that?
Nope.
Okay. I'll go ahead and I'll make the second.
Okay.
And then we can put that up for public comments.
Are you taking, is this public comment?
Yes, Anonymous, are you ready with a public comment?
Yes.
Go ahead, sir.
Thank you. I just wanted to comment on the notion of whether or not records exist and what this group of this committee should determine or even recommend about that. And I don't think it should make any recommendations or even believe an agency. And the reason I would say that is you can go back and look at case 19047, where I alleged that the mayor had certain calendar records. And the representative for the mayor's office, Hank Heckel, who is a lawyer and who under the rules of professional conduct has a ethical obligation of complete candor to a tribunal, came to this complaint committee and told that there were no other calendar records. A few days after that committee hearing, they then turned them over. So it is not always the case that when the agency simply claims or represents that records don't exist, that is true. And I'm not saying that Mr. Steinberg is lying, but someone in the agency might have them and not have turned them over. And the only way I was able to get that was by filing yet another petition with the supervisor of records, who used his authority as the lawyer for the city to go and ask whether they were, and then they did turn them over. So it is possible that just because an agency comes to a complaint committee and says that there are no records, that the records do actually exist, and they are eventually turned over. And so contrary to what a previous commenter mentioned about me, I'm not a lawyer and I'm not providing any advice to the parties. But it is possible for a person to also file a simultaneous supervisor of records petition for the same request and see what the city attorney's office digs up, which maybe this task force may not be able to dig up because they can't go rifling through DPW's files. Thank you.
Thank you. Anyone else with public comment on this matter? It does not appear so. So let's vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Forsley?
Aye.
Member Forsley, aye. The motion to forward to the full task force that the records are public and there is jurisdiction and find a violation of timeliness and no withholding violation. Seconded by Chair Schmidt. Did I get that right?
Sounds good. How's that, Member Stein? All right.
I think that was correct. Yeah.
Okay. All right. So let's move on to the next case.
Item number 9. Excuse me. File number 20095. Complaint filed by Carl Kramer against the Human Rights Commission for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and/or complete manner.
All right. And again, we have Mr. Kramer. And is there anyone here on behalf of the Human Rights Commission?
Yes, Cheryl Davis from the Human Rights Commission.
Okay, great. Thank you. We do have someone. So we'll have 3-minute presentations from petitioner and after that from respondents. So Cheryl, when you're ready, we'll start with Mr. Kramer.
I'm ready.
Mr. Kramer, go ahead.
Yes, so on this, the initial request was sent June 11th. July 25th, we filed a complaint. We then were, let's see, on page 905, you'll see an email from Camila Tofik from the mayor's office that Ashley, and we take it that she's referring to Ashley Groffenberger, is working on this with the lawyer in the mayor's office. On page 906, you see August 25th email from Isabel Katapang in the controller's office that this is a policy decision for the mayor's budget office. And page 907 is August 25th email to Brad Russi and take it that he's in the city attorney's office, and the person with the Human Rights Commission is making comments that you don't get the department or the city in trouble. Page 849 email on July 27th, questioning whether this information is commonly shared with this CBO, that's a community-based organization. So it just seems to us that there was political reasons that the information was being held back, and that we weren't getting a response to our information request.
Okay, thank you. Now when Cheryl's ready, we can hear from the representative of the HRC.
Okay, I'm ready.
Oh, and just to clarify, there's 2 people named Cheryl here.
I was
Davis.
just figuring that out. Thank you.
Yeah.
Okay. Cheryl of the task force, are you ready?
I am. Are you ready, ma'am?
Okay.
Ms.
I am.
Cheryl,
So, okay.
Go ahead, ma'am.
Okay, thank you. So first and foremost, just to acknowledge that the request came in June. The Human Rights Commission had several staff, one of which was the person who manages our sunshine requests that were deployed and out of office. And we also, myself, the director, as well as other directors, were all working at COVID Command Center. So we were backlogged. So there's time delay on that front. Next, so we had several people DSW deployed, and we still continue to have several of our staff deployed, so we are backlogged in that. Second, the initial request actually went to someone who no longer works for the Human Rights Commission, has not been there for 5 years, and so it went to 2 emails. One to one that folks are, as we were remote and people were being dispatched, was not checked as often. Another to a woman who no longer works in the department. And then another staff member who was managing that went out on sabbatical at once the pandemic hit. And then I'm just trying to read my notes. And then similar to the previous conversation with Department of Public Works, it's information that we do not have. Most of our grants and our contracts, they give more than minimum wage. So when we have conversations with our grantees about the amount of money of their staff and what the impact is, they, assure us, and then it's in their grant, that they actually pay over the $17, the $17.04, the $17.35. So that is how we consider the calculation. So most of our conversations are with our grantees directly and not via the other pieces. I would imagine that the mayor's budget office got involved or engaged because we were backlogged and they knew that we had staff deployed. And we have since, for the request that came in recently, I actually have reached out. Just personally, I just recently returned. My father died, so I've been out of the office. When I came back, I reached out to Living Wage, 3 different people. No one has yet responded. But we had similar things where we weren't sure that it was a request when we finally got it. We circulated it to our mayor's budget office and other folks to ask for help.
30 seconds, ma'am.
And so we've been trying to ask for help, and we have also at this point in time initiated with our contractors a process to get an email from them, a response to be able to share when these requests come in. But there's no documentation that exists, just conversations that we've had.
Okay, thank you. Is there anyone else here who is a witness on this case? Not
Jen, I don't know if you want to. Yeah.
Oh, I'm sorry. Go ahead.
No, I was going to say Jen Liang, who is manages our contracts and the financials, is on the call to answer questions if they come up. And I know he has also reached out to the Living Wage Coalition to ask for help and a better understanding of what they're asking for.
Okay, great. So we have another person available if something comes up. Good. Thank you. Okay, members, obviously some big similarities to the last case, although not identical. Any questions for the witnesses?
I may have I may have missed it, but when was something actually produced, if it was produced?
So nothing was produced in the last year. We have been emailing over the last month with Living Wage and sharing things. Actually, we did produce things in August, but they told us they didn't want, or that what we sent them wasn't what they wanted. And so much like the previous caller, we didn't understand what the requests were. We asked our city attorney and other folks for help because the document they asked for we didn't have, and we didn't fully understand what the request was.
And the types and the initial response, I remember the June timeframe, there was a lot of things going on, but the initial response to the person was what date? An August date, or was it an earlier date?
We had some dates in July where I think, actually, to be honest, I think Cheryl emailed me. That's the first we knew of it. She emailed me that there had been a complaint. So once we got that was the end of July.
August 3rd.
August 3rd. Okay, thank you.
So this is Member Stein, and I do have some questions for Cheryl Davis. Did your office prepare any budget requests or funding allocation requests for the 2020-2021 fiscal year?
I don't understand the request specific to the MCO.
Did you prepare any budget requests of what your office would have to spend in the 2020-2021 year?
So, I mean, we do our typical budget submissions. John, feel free to weigh in. And then we have to present our budget, but not line items necessarily. They're big bucket items that say how much we're getting in grants. And then we negotiate with our grantees on the back end.
So we do also have, similar to the DPW, when we submit our budget, we also have that checklist where we have a check line item saying that we have considered our budget, MCO in our budget.
So you have okay. So that was your So that was your understanding of providing written confirmation that you considered the MCO, was that you have that check off.
That's correct, because we were trying to get help from for example, MBO, because we did not understand what the request was, because as I understand it, it was that checklist, and then we also talk to our grantees about MCO. In fact, in all our contracts, there's that MCO clause that makes sure that the grantees need to abide the MCO rule.
So you basically consider that clause notice to your grantees that they have to provide that cost of living increase.
And also, right,
yeah,
and also what the director just mentioned, that we also have our staff communicating with the grantees about that. That's how the director can just mention that they pay actually more than the minimum wage that's required.
And so our considerations are verbal, and that we do that in their contract negotiations. And so we did, through this recent year, through the request that came in, we did initiate through email to ask our grantees to let us know or to confirm that they are paying. And we only have 5 grants, but two of them have already responded back and say they pay more than the $17.50 an hour with the funds they use for our contract.
So if you gave them a grant, are you auditing that they did in fact pay out monies that are in accord with the MCO ordinance?
It's in their grant contract. That's
okay.
So it's mandated in their grant. The grant agreement itself says, as John mentioned, the grant agreement says that they are bound by MCO.
Okay. And then I guess this is a question for Mr. Kramer. How does this differ from what you believe that MCO requires?
Well, it sounds like there was communication that was taking place, and we would have been satisfied with what the notes were on that communication. If it was that there would be 0 additional funding needed to for those nonprofits to increase their wage rates. I mean, that was the information we were seeking.
That's all my questions.
Okay. Anything at this time, Member Forsley? Nothing.
No, thank you.
Okay, thank you. Let me just find out first. This checklist, Mr. Kramer, did you get a copy of the checklist from the HRC?
We did not.
You did not? Okay. And this is a question to the respondent. Would you be able to provide a copy of that checklist to Mr. Kramer in response to his request?
So I have been reaching out to Mr. Kramer and the other folks over the last few weeks. I think we may have emailed that. So I actually tried to meet with them upon returning from my father's funeral. And no one has responded.
Okay, so it's not that you're withholding it, but you are trying to send it to him. Is that fair to say?
I'm trying to get clarity on what he's asking for. I asked for them to, I believe it was last week I followed up and asked for someone to follow up with me because I didn't understand. I don't know, John, John and I both emailed something recently and never heard back.
Okay.
Right.
Sorry.
Just a quick.
Right. There were different people contacting us. I'm sorry. Yeah.
This is member Stein, and maybe Mr. Kramer can speak for himself on this, but it's my understanding that he wants confirmation that there was some kind of documentation that the cost of living increases demanded by MCO, that documentation be produced, as well as any evidence of the considerations that went into making sure that the MCO was followed. So that might include things like if there's no actual budget item, that could include communication with your grantees about the MCO, for instance. But maybe Mr. Kramer can speak on this too.
But I just want to say that my point is that we did that, and all of those things they told us they didn't like what we said or they didn't want it, and up until last week, or 2 weeks ago, everything was verbal. We've started a new process in order to not keep doing this because we didn't have clarity, and so there's much like the previous caller, right? There's just the phone calls that our staff has had with the grantees. So we submitted things previously and we're told, nope, that's not what it should look like, or it should be this thing, but it doesn't exist for us, much like the previous caller. We've just been trying to be, we've tried to be accommodating, but it doesn't, you're asking us to create something that doesn't exist in order to be responsive to this, right? So there is no documentation. And we're willing to work with him to get to what they want, but there is no documentation on our end. The way that we consider it is through our grant agreement, which I believe John actually shared a piece of what the grant agreement says, and through our conversation. So we've submitted that, but we're told that that wasn't adequate.
Would someone forward that response to us? And you were saying that what is the best email address for you?
Let me just intercede. It sounds like Mr. Kramer would like a best email address for the respondent for communicating about this.
Well, it's the one he emailed me to. I've been responding to his email. So it's cheryl.davis@sfgov.org.
Okay, thank you. Thank you.
And, yes, and we didn't, I don't think we received those emails that you sent. So I'll send you an email, just make sure you have our correct email.
But Ms. Davis, when you say you were responsive, you're talking about the sending, the thing that you sent was the clause that you include in your contracts, correct? That's the response.
No, I'd have to go back. I know that there was a response sent in August. There were other, we've had some ongoing kind of back and forth. And typically when John has said something, they've said, thank you very much, but this isn't what we're looking for. And then we try to come back and we try to be responsive. And so, I asked last week I need to look at, I think, John, you had pulled it up, the names. I'd asked someone to actually call me because the email was not working. I'd asked to meet with someone because, you know, we've been submitting stuff since last August, and it's always told that that's not what they want. Mm-hmm. And so I guess we're being asked to create something.
I'm going to, Member Stein, did you have a follow-up?
I don't have anything else to say. I'm just wondering if it might be productive for them to have, in the context of this meeting, a brief conversation to see if they can come to an understanding of what's being sought.
Sure, that's fine. If the parties wish, go ahead. Go ahead.
What June had emailed was a kind of a separate provision in the minimum compensation ordinance that to include in contracts with the nonprofit organizations with which you contract, that basically the language is that they need to follow the MCO. But that's not what we were requesting. We were requesting the information based on another provision, which is not the compliance of the nonprofit organizations, but the compliance of the department, that they would submit their written confirmation, that taken into consideration these calculations, and then we're requesting that those calculations. I can see that their process is, it was maybe less formal or over the phone, but there was a communication going on, and that's really was the intent of the legislation, that there is a communication. But then we would want to see a response that we've had the communication and everyone's paid at a level that they wouldn't, these nonprofits wouldn't require additional funding to raise wages.
And as Mr. Kramer had said, he has not received the checklist, and it sounds like that's something you'd like to send over, Ms. Davis, but you haven't quite sent it over yet. Is that right?
No, I'm looking. Jen sent that on March 8th.
March 8th. Okay, so last month. And but the document that ultimately you feel is the document that he's saying he wants, that's just not a document that actually exists in that form. Is that fair to say?
That is correct. And so what we did in order to be responsive is I asked the staff that manage the contracts. John sent an email and we requested formally for them to confirm that all of the grants would pay above the 1734 that was outlined in the piece, so that we could be able to share that with living wage. So we started that process just to be able to document that we have had conversations. Typically we just have the conversation, but now we are requesting, I did it via email to be able to share it. But the grantees not all the grantees have responded, but there is no document.
Okay, thank you. Thank you.
Hey, could I say something very quickly?
Yeah, that's fine. Go ahead.
Yes. I mean, we're more interested in the process. So if we receive, this complaint is based on information request last year. But if we receive the information for this year, I mean, we'd be willing to withdraw the complaint.
Okay, so that's a message to the respondent. I think that we probably will end up doing something similar to what we did with the last one, although here maybe there's a few facts that are different. Okay, members, if you have further questions, that's fine, but otherwise, any ideas on what you want to do with this?
This is Member Stein. I mean, I do feel similarly to the last case, even though the facts are slightly different, that what we have here is a disagreement about what the correct process is for following the MCO, and it seems like HRC, just like DPW, is not following it. I mean, I think what these two requests have revealed is that it's not being followed in the way that the Living Wage campaign believes it needs to be followed. So that is information in and of itself. But if these documents are not there, they're not there. But clearly, this was not provided in the time frame that normally is requested. But then again, this is also a case where it was provided eventually. It wasn't as long as the last case, and you do have COVID as a mitigating factor. So that's my thinking. I'm not really proposing something at the moment, but
I pretty much where you are on that, and I think that there's a chance that they were out dealing with coronavirus things for many months. I don't know, and so. I don't know what we can do to, deal with that in terms of what our decisions will be. And maybe that's where we just say for today, let's figure out what we can figure out before we pass this thing along. I think whatever documents exist or would exist are public jurisdiction. I think that we probably, at least with the checklist, which I think maybe you could say that the delay was significant here. If we say that the checklist is within the scope of the request, then maybe there's a timeliness issue there. Although I think that the specific document that's sort of at issue in all these cases and yet may not exist in some of these cases, that does appear like it actually never was generated. Who knows if the legal requirement is that has to be a specific separate document. I don't know. Again, that's not my decision. We're just looking at documents here. So yeah, I'm pretty much right where you are on that. We probably need to pass it on. Do you feel, either member, that we make some kind of clarification when we get to the task force, or do we make a recommendation so that we expedite at that time? I don't know. I can't think of anything myself.
I'm wondering if we can do something that says we recommend taking it forward pending hearing from the parties involved, whether they were able to come to some kind of mutual agreement about, how this MCO process should work in the context of HRC.
That's great. Yeah. Let's, if they can work this out and they don't want to go to our full task force to hear this again, that's a great result. And this might be a case where that's the best result. Mm-hmm. I don't know if they're that far apart. They sound like it's whatever is out there could be given, and then maybe they can talk it out and it's over. And so yeah, let's make that a provision of our submission up to the full array of task force members.
All right, do you want that to be part of the motion, Dean? Is that what you're saying?
Yes.
Chair Smith, can we add a time limit to that? This is Victor Young.
That's a good idea.
Yeah.
Otherwise, it'll go into limbo if nothing happens. We should set a time limit on how long we're willing to wait before we schedule it before the task force.
Good.
I give 60 days.
Or 30. What about 30? Is that something 30 days? Could be done in 30 days? Because I feel like this has dragged on for a while already.
This will be more than 30 days because the next task force hearing is in 2 weeks, and then it'll be heard in June. So that's 6 weeks right there.
Okay, I just don't want to delay it too long because I feel like the petitioner should be able to have these issues addressed.
Member Stein, just due to the backlog pending before the full task force, it could be possibly 60 days to 90 days already, just because there's so much backlog waiting to be scheduled before the full task force.
Right, but does that 60 days include like whatever time the petitioner and respondent would need prior to being scheduled to submit any additional documents and things?
Is that your discretion?
I don't want it to get delayed beyond what, whatever its next hearing would be, I guess is what I'm saying.
This is Member Forsley. I would agree with Member Stein. I don't think that our time frame has to be dependent on when the case is actually heard before the board or before the task force. I think it can be.
Sorry, go ahead.
Yeah, I think it can be scheduled for a time frame, and then whenever it's scheduled to be heard.
Yeah, I just think 30 days is probably sufficient.
For the two parties to come to an agreement? Is
Yeah.
that what you're saying?
Yeah.
Okay, yeah. But when it'll actually be scheduled like that, I can't guarantee.
Right, no, I'm not talking about scheduling at all. I'm just talking about that it should go forward pending within the next 30 days, the two parties, unless the two parties can reach an agreement in the next 30 days that is mutually satisfying to both.
I believe at that point, the petitioner would just simply withdraw their complaint, and they would not need the agreement of the task force or the committee. They could just withdraw their complaint at any time.
Yeah, and I think that's sort of what we're hoping they do, is that there's not that much that really needs to be resolved here, and unless Mr. Kramer wants, an order from us declaring that the delay was unlawful, which he's entitled to. If he gets everything else but that, maybe he'll just decide, good, we're done. And so that's what we're hoping will happen in that 30 days.
All right, so are we making a motion here?
Yeah, a motion to move this complaint forward to the full task force, because it is a matter of public records and it is under our jurisdiction, unless an agreement can be found in the next 30 days as to how the MCO process should function.
MCO is an octopus, or MCL is in leg?
O is an octopus.
Oh, it's octopus. Okay. Thank you. I'm glad I asked that. What I was going to suggest is move to find the records are public. It falls under jurisdiction to forward to the task force, pending an agreement between the two parties within the next 30 days, and to pending an agreement to exchange records within the next 30 days. How about that?
Yeah, in which case it can be, hopefully it would be dismissed.
Okay, if you got that down, Cheryl, all we need is a second for it.
I'll second it. This is Member Forsley.
Okay, thank you.
Thank you.
And so we have then it's time for any public comment on this case. Is there anyone here who wishes to make public comment on the matter?
Anonymous, please.
This would be public comment on the motion, Dean.
Oh, I'm sorry, on the motion. Yeah. Or yeah.
Anonymous?
Yes.
You may proceed.
Thank you. Two things. One, I don't think it's right for the committee to hope that the complainant, I think that word may have been used, hope they would dismiss it or hope they would withdraw it. I think the committee and the full task force should take it as is if it is there, even if the complainant has the option of withdrawing, because I don't think they should have to feel any pressure to withdraw the complaint. As it regards to the what could be found, there's actually quite a bit of documentation on the Office of Labor Standards Enforcement website of the city about what exactly are the records that show the evidence compliance with the minimum compensation ordinance, including, it says 4 departments, these declarations signed by their contractors, the department's contractors, known as minimum compensation ordinance declarations. And so they might have those records, and they should be able to produce copies of those. And they, one could request, all communications between the department and every one of their contractors that references the minimum compensation ordinance. So there's things one can do, even if there aren't any calculations, broader requests that one could request to find more of this data if one wished to keep digging. That's it. Thank you very much.
Okay, thank you. Is there anyone else who wishes to make public comment at this time? Okay, oh, yes, Member Stein.
Yeah, I just want to respond to Anonymous and maybe also to address the petitioner that I don't in any way intend to pressure the petitioner to dismiss this. I'm really responding to the petitioner's statement that they would be willing to dismiss it if they feel that a proper process is being followed going forward. And I'm just trying to put a time limit on how long it takes to figure out that process so that the petitioner can know, like, yes, this has been addressed sooner rather than later.
And I found your remarks to be very helpful.
Thanks.
Thank you. And Member Forsley, did you have something?
Yes, I was actually going to say, in response to what Member Stein was saying, one thing as a new member, it seems like in some of the cases that people like actually really want a resolution. And so I think that if we can get to a resolution, in some cases, obviously we should violate people because it sends a message or whatever. But if there's a resolution, I think that's also something that is really, that we should be working towards as well.
Thank you.
And I, as chair, I completely endorse everything just said by the other members. Yes. Very important points on what we're doing here. Okay. I don't think there was any other public comment. And so I think we're ready to vote on the motion.
Okay. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. The motion to send to the full task force that the records are public and under jurisdiction pending an agreement between the parties to exchange records within the next 30 days. Is that correct?
Yes.
So once you have that secured, Cheryl, we could move on to the next item.
Yep. Item number 10. No, item 11.
Yeah, we'll pass 10. It's
Yep.
not here today.
Let me check my record here. Item number 11, announcements, comments, questions, and future agenda items by members of the complaint committee.
I think just as a chair, I'll say that in this slot on our agenda, unfortunately, we always hit this slot when we've been through hours and hours of hearings. But I do think that we should feel like we can talk at this point because we're constricted by, open meetings restrictions. But this would be a time when we can talk about how we run the committee, suggestions, etc. I don't have anything here today on that, but I may in the future. And unfortunately, it's at the end of the day when people are probably ready to move on to something else. But I encourage anyone on the committee to talk at this time, because this is our point where we can do it, and we can do it legally, and then we can have other people comment on what we say. That's all I have to say at this time on that matter.
Well,
Anything from, oh, go ahead, sorry.
Yeah, I mean, I agree with you. It's like your brain is just like very tired by this point. But I do want to make sure, I think we should bring up to the full task force that we really need to clarify where the mayor's emergency orders stand at this point. I mean, I would be willing to call the mayor's office and try to like pin someone down about what's happening, but I don't even know, that I would get some kind of response that way. But I think this is probably for the next year or two going to be an issue, right? Because everybody is going to say, well, there were delays, but it was because of COVID. And maybe we need to develop some kind of guideline about like what's a reasonable delay. So I definitely think this, I know that there's some subcommittee that's going to work on this, but I think we really need to press on this a little bit. And then just something else I wanted to raise, because this, I'm on this committee and then on the full task force. These packets are pretty voluminous. And even though you don't have to, even though they're bigger than they appear, because there's a lot of repetitive information, I keep thinking like it's just so hard on your eyes to scroll through 1,000 or 3,000 pages of documents, many of which you've seen like again and again and again in different people's email threads. And I almost feel like this is something that should be addressed too. It's not only difficult for us as committee members, it's difficult for members of the public to really review what's happening. And it seems maybe there's a way around it. Like maybe every item, every email or something could be itemized somehow, and then just one copy of everything put in there so that we're not just like scrolling through hundreds of pages of things we've seen before. So I just want to bring up those two issues because every time we do these meetings, I'm like, it seems like there has to be a better way.
Well, you know what? To address that, I have to tell you, I get emails from both sides, and I have to pick what goes on the respondent side and what goes on the petitioner side. And I try to include as much information as possible for each party. And yes, things will have been repetitive, but it's because I'm trying to give both sides an opportunity to say what it is they want to say, because they both addressed the same email. So
yeah, I mean, maybe it's hard to do, but I just wonder if if you have an email dated this date and this time, itemize it, give one copy of it. Seems like it could be possible.
I would agree with both concerns. On the second concern, I think there must be some way to edit, although I would say that that's probably not as easy as it sounds.
I fully recommend that,
yeah. And so both, if we can do it, great, yes, but figuring out how to do it is probably that's the key.
Yeah.
On the first concern, I don't know if the mayor's orders are technically giving us too much restriction, other than our order that we have to do this remotely, that we can't go into City Hall, etc. But I don't know if the orders about the suspension of the rules are actually affecting the cases that we're seeing yet, although it may be that the cases that we're about to see in the coming months will be affected by the mayor's orders. And so, yeah, we ought to be knowing what the status of those is, and we should probably, bring it up at the full task force that's an issue.
I have a suggestion. If that's an issue, maybe you could ask Chair to get in touch with Mark Pricewolf to give us an analysis of where all these supporting mayoral proclamations stand. I mean, maybe he can do a memo for us that says number 5 is this, number 10 is this is what we can expect in number 12. I mean, maybe he can't if he knows the material well enough to be able to do that. Or give us an analysis at the next task force meeting on where all this stuff stands to give him time to do the research.
That's a great idea, I think.
Yeah, and I think that trying to make that communication is a good move, because we would hope to have, some kind of a turnaround in getting that kind of advice from the city attorney's office. However they prioritize things over there, I don't know how quickly we'd get it, but we can only figure that out by trying it and seeing what gets done.
So
And
we send a letter as a committee to Chair Wolf, or can you just request it, Cheryl, or what's the best way to do that?
I think Dean should speak to Chair Wolf and tell him what we want. I mean, I can say something, but this really should come from Dean.
Okay.
And if you want me to do that, Member Stein, I will do that. And we're basically trying to get a status on what is the impact right now of all the various orders on COVID coming down from the mayor. You don't want governor stuff. You want mayor exclusively, right?
Correct. I mean, as far as I know, I didn't see anything from the governor that impacted the CPRA, but there's like 13, 14, I don't even know how many now, mayor proclamations. Yeah. And it was kind of surprising to me that in my search of news sites and elsewhere, I couldn't find anything about what their status was. Mm-hmm. And, it doesn't seem like there's been any communication to the relevant departments about, beyond these proclamations. Like I never got an email as a committee member about where things stand now vis-a-vis the Sunshine Ordinance. And that seems like essential communication.
Yeah. And that's within our ambit to figure out what do we do here, and that's affecting us. Yeah. So I will send a request to the Chair Wolf, and it will get to Mark Price Wolf, and I'll get that in process right away.
May I ask what you're up to? And I just joined, and I'm wondering what you're up to and whether you've taken public comment.
On item 11, Mr. Warfield. We're on the
Item
very
11?
end of the hearing.
Yeah, and I was just going to say to Chair Schmidt that this seems like an important thing to have too, just even for that ad hoc committee that's being put together to try to address this issue, to maybe first have a presentation of the legal advice that would be given to us about it. Yeah, so we are just discussing where the mayor's emergency proclamations stand vis-a-vis the Sunshine Ordinance, whether they've been rescinded or not, our lack of information on this.
I'm thrilled to hear it because I've been asking for that for some time. Mm-hmm. But has public comment been taken on this? Or
we're about to get there, and it'll just be a quick moment. But I don't think I have anything else at this time. Do either of the members have anything? And then I'm going to go ahead. We've done our number 11. And this is the last item before adjournment. So I will open up to public comment on that. Cheryl, just tell anyone who wants to give public comment when you're ready.
Mr. Warfield, are you ready? Go ahead. Mr. Warfield,
I didn't
go ahead.
understand. We're talking at one time. This is
Mr.
Peter
Warfield, go ahead.
Can you give me a 30-second warning, please?
Do my best.
Yeah, this is Peter Warfield. As you know, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by U.S. Postal Service for P.O. Box 170544, San Francisco, California. 94117-0544. And as I've said before, I give this information in part because there is not the opportunity, as in the real world of meetings in person, of people to go up to each other and say, let me give you my card, let me give you my phone number, how about if we have a cup of coffee sometime, and so on. I'm thrilled to hear just the portion that I heard about the difficulties that the Sunshine Ordinance procedures have with respect to the enormous number of pages and the repetition. I think that was Ms. Stein who was speaking. There are a lot of problems that I think have existed with the Sunshine procedures. Absolutely, the repetition of strings, you know, where you get A, B, and C, and then you get A, B, C, and D, and then you get A, B, C, D, and E, and so on and so forth, and you have to go through the whole thing to see what's new, and so on and so forth. That needs to be figured out. Some of the procedures, I think, are certainly within your control. I have to say, unfortunately, as an example, though, some of the administrative things I think are unnecessary and I think should be reviewed for necessity in the file that you get for making a decision about a complaint. I think perhaps more should be given to the complainant to choose what goes in the file, and maybe the respondent as well. I remember early in the time that Cheryl Leger was working at the clerk's office, I had requested from the Library Commission, from the library, it turned out to be hundreds of pages of reports of discipline against, serious discipline against members of the public. And there were, I don't know, 1,000 pages, 500 pages, 2,000 pages. It filled a whole box. And Ms. Leger insisted that I give them all of the pages. And I said, wait a minute, I just need to show that what I got was chopped off. And I don't need, you know, the complaint is that they gave me a chopped off version of the record, and I wanted to include something like 9 pages.
Your time is up, sir.
Oh, 30 seconds.
42 seconds.
30 seconds warning. I'm sorry, Cheryl.
Okay. So, so that was a gigantic effort on my part to get all that stuff together. I didn't think it was necessary. I think ultimately it didn't go in. But in any case, I think how those are structured and what goes into the file and the sequencing also, I think it should start with a complaint. It should start with the response following, and anything else is probably superfluous. But I'm glad you're looking into it, and I hope that you have an agenda item, because I'm sure there are plenty of people who might have something to say that would be helpful about their experience and about their suggestions. Thank you.
Okay, thank you. Is there anyone else here for public comment at this time?
Yes, anonymous, please.
Okay, when Cheryl's ready.
Go ahead, anonymous.
Thank you. I would agree with both comments of Member Stein. I do think that, and I've experienced it in my cases as well, that it is not a need for all the pages that are in a hearing. I think it might be helpful to simply, because a lot of those pages are the back and forth between the respondent, the complainant, and SOTF administration about when to schedule things and whether they've gotten copies. And I understand that those may be part of the evidence that the SOTF can consider, but generally doesn't consider it. And maybe it can just be in an appendix. So it's still there, right? Everyone can look at those extra emails. It might help to just allow each party to say, what do you want to be presented on your party's behalf to the task force? And that's the stuff that's just included in the main part of the hearing file that you all see. And I think it would be a lot clearer what is happening in that circumstance. I would also strongly suggest that you fully digitize these files. It would be so much easier if you had an automatically generated table of contents that you could just click on and you could see each document, right? Like complaint, response, reply, or rebuttal, whatever you want to call it. And I think that would make everyone's lives a lot easier. I understand some people do not use electronic files, and of course they can get printout copies. But a lot of us do use electronic files. The files could be much easier to search through if everything was just an actual email and not a printed and scanned copy I think everyone's life would be a lot easier. And I also believe this task force made a motion to write a letter to the Board of Supervisors to revoke certain of the emergency proclamations that was approved by unanimous consent of the full task force. And as far as I understand, that has never happened. And so as part of that discussion, I believe you need to resend that to revoke it, everything except the timeliness, I believe, is what the task force decided, is that, okay, well, the timeliness might make sense during COVID, but these other things about
30 seconds.
Balancing tests and contracts were not something that was in the public interest to do. And I think you need to send that letter to the Board of Supervisors so they can use their authority to rescind those portions of the emergency orders. Thank you very much.
All right, thank you. Is there anyone else with public comment at this time? Okay, public comment is closed on that matter, and we can move on to the next number. Cheryl?
Item 12 is adjournment. Who moved?
Okay. I'll move to adjourn.
Second.
Thank you. Okay, we are adjourned.
It is 8:45 p.m.
Yeah.
All right, I will
Thank
turn off
you.
the recording.
Great work, everyone.
Yeah, thanks all.
Thank you. Bye.
Good night.